Who will decide how to define personal information in Europe? Will it be the EDPB? Will it be individual DPAs? Will it be new legislative language under the Omnibus Digital Reform, EDPS? Or, surprise, surprise, will it be the officials of the Digital Markets Act? Here's why we need to pay close attention to what is happening in this DMA action that is requiring search engines, Google in particular, to share search results with competitors. So, as I think many of my watchers know, the DMA aims at supporting competition by ensuring that large platforms that have certain market positions share information with competitors. The Google search litigation brought by the Department of Justice in the US found that Google had to share search queries with competitors. Now, here's why this ends up being pretty complicated. And oh, by the way, why do I care? This is something I have a lot of interest in personally, because when AOL shared search data with researchers, posting that on a server for researchers who were previously getting it one-on-one, all hell broke loose because the data could be re-identified. Now, AOL posted it with a unique identifier and then a longitudinal list of queries. And so people, although their screen name might have been scrambled, there were trivial items in there. People searched their own names, maybe an address, things that made it very, very easy for reporters in very few, but in a few of the search logs to call up those people and say, oh, are you the Maria Jones? And here it says you searched for all these embarrassing things. Is that you? Well, AOL decided it needed a chief privacy officer. It didn't have one. And I became the first chief privacy officer. Interestingly, there were researchers who continued to be interested in AOL search results. We had the biggest, most extensive set at the time. And researchers wanted to understand what was going on, what are people searching, and all sorts of interesting behaviors, academic researchers. And we wanted to support researchers in understanding the internet. So we looked hard at what it would take to de-identify search results. And the top search results are easy. You often see companies, Google or others, publishing lists of what the top queries are, right? Searches for this celebrity or this particular topic. Easy to do. And the competitors typically have those results because people are also searching at the competitors for those results. So they've got the query and they've got their own answers. But a vast amount of queries are a very, very long tail of results, things that a small number of people search. And that makes up a lot of search results. And the smaller search engines don't have as long an exposure. And so they may provide you good results when you search for Donald Trump or Taylor Swift or that sort of thing. They may not have as good coverage on many, 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 many results that are searched by a small number of people, but lots and lots of queries. And that's one of the key things that the competitors want. Now, here's the challenge. The goal is to provide it almost real time. And it can be very difficult with this very long tail of anything and everything. I mean, people put all sorts of information into that search box. And remember, this is not just people who go to, Bing.com, Google.com. Many people use that search thing almost as a kind of as a browser, right? You just stick in the word and then you see what comes up and you choose the result you want as a way of almost navigating. People paste in Google Docs, hidden URLs. People paste in passwords. People paste in all kinds of information. And it can be very hard to determine in advance whether some of this is personal information. Consider Jack Smith, a very generic name, and the name of a very high-profile figure in the U.S., one of the prosecutors who got a conviction, but, he ended up dropping it in the end when Trump became president, but who prosecuted Trump for the Mar-a-Lago files. And very legitimate, result for people to be searching. But of course, it's a very generic name, and there are Jack Smiths who then search perhaps for a particular pharmacy drug, and then maybe they put in their address. Searching an address sometimes is my address, sometimes it's looking for a general location. High dimensional data that we don't know what it's going to look like in advance, can be very, very hard to de-identify. You don't know what you're seeing. You can't easily come up with every possible way to screen that information out. Okay, so this is our problem. In the US case, the judge, after hearing a lot of testimony, appointed an expert committee. Somebody Google proposed, somebody the attorneys general, who are the plaintiffs here, proposed, and then sort of a third. And they're going to have to figure this out. So there's an expert group. The officials of the DMA are not happy with whatever has been proposed so far. And the plaintiffs, the people who want the data. And the DMA officials are going to determine what is de-identified in this unique use case. Ordinary text as well, which is key to de-identification for training data, right? Ordinary text, it's also pretty high dimensional. There can be lots and lots of different items in there. So it's really important to see how this comes out. Now, the ECJ has provided some greater margin for practical de-identification in the SRB decision, where pseudonymized data was determined to be personal in the hands of the original control of the data, but could be non-personal in the hands of a third party who didn't have the key to that information, but who had lots of text. Now, let me note, lots of individual text comments by users could be personal or could not be. You need to do an assessment. And if you have a limited amount, comments that people sort of put in that proceeding, you could take the time to, carefully go through it and make a decision. But what this means for this very high dimensional search data, I think, is a lot more complicated. I didn't read the decision as giving us information about whether or not there are techniques that are feasible to de-identify vast amounts of sort of long tail data, right? But rather a data set that clearly has some lookup information externally held in the hands of a trusted party. The court has given us room to say that there is pseudonymized data sets that can't be identified without the additional information that is in the hand of somebody else. And let's take a look at whether or not that is strictly protected. So I don't see the SRB as really kind of providing a lot more flexibility in this particular instance, but I don't know that that's what the officials here are going to conclude, from it, and how they opine may give us another view. Now, at the end of the day, DPAs obviously have the last word, but with regard to interpretations elsewhere, but it certainly will create a lot of confusion if the opinion here is very different than where the DPAs who have already sort of opined in a way that shows a perhaps narrower view of the takeaways of the SRB case. So anyway, keep your eye on this because it's one where either because of the pressures to allow this data to go, the DMA will take a very liberal view that could set some precedent, or maybe it won't be precedent for others, but will create a divergent path that will be a point of confusion. Anyway, pay attention. Okay, I wanted to talk about one more topic. I was in India last week for the India AI Action Summit. Phenomenal experience, very democratic event. The other summits in Paris and previously were really kind of elite events for invited parties. Here there was a giant expo, vast numbers of people, several 100,000 could come to both the expos and the programs. So every room, every meeting was just jammed. It was really hard getting in and out, traffic, but really a very democratic process. Lots of the programming also was very broad, although the top level debates between the CEOs and the governments may have been focused on things like chips and data centers and business. Lots of panels on governance and responsible AI and inclusion. A lot of the messaging around the conference as well, very focused on how to ensure that the different cultures, different languages in the global south, India as a champion, would be reflected in AI. I encourage people, to read the US statement from the OSTP, which I think had some language around sovereignty that is worth reading closely. Certainly there was a clear statement from the US that it didn't want to submit to international regulatory obligations that could be restrictive. India, in some part, was in agreement that supporting AI should be the focus of regulation. But the US did recognize that different jurisdictions have clear rights to think about their own sovereignty, but argued that don't cut yourself off from the best available technology, the US tech stack, in your drive in that direction while you support and try to spin up your own local champions. So just sort of an interesting framing. There was support for a national framework, didn't specifically say legislation, but a national framework for legislation in the US. One thing that we were explaining to people was that the legislative picture in the US is actually much more complicated. There are lots and lots of states that have moved forward, continue to move forward. There are lots of both Democratic and Republican leaders in the House and Senate that are determined to ensure that there are certainly sector-specific AI regulations. There are 40 plus state proposed laws around data-driven pricing. The affordability issue is driving a lot of the interest. Governor DeSantis of Florida has been a big champion of AI regulation. You've got members of the House and Senate. So there's a much more complex picture, although it's clear that the federal administration is pushing back hard on the states. You saw some actions against a very Republican state like Utah, where there was some real pushback. But the actual regulatory situation is indeed much more complex, and one should expect to see a lot of AI regulation, chatbots, youth, data-driven pricing. We already have states that have regulated foundation models at a very high level. So taking note of what's actually happening on the ground if you're looking to see how your national rules intersect. The other point that I made was that India has put in place a data protection regulation, and in so has put forward law that will regulate AI. The law allows scraping if the data has been made manifestly public, but what exactly is in there and what isn't in there, that'll tell us about the legality of scraping for training. It's a big opt-in consent law in general. So what about training data that's not public, but using data you hold for some secondary purpose? Are users going to have to consent to it? Is there de-identification? How will that be determined? If it's de-identified, it's out of scope. But what is the guideline for de-identification in India? So we should expect to see MeitY providing details and clarification. Probably not the DPA. This is not going to be an independent DPA, as was noted to me by officials. It'll be an adjudication DPA, but adjudication determines policy depending on how these things are handled. But it's clearly the intention of the government to be the policy setter in support of AI regulation. But how the law ends up being framed and interpreted, Bilal Mohammed, our India lead on staff, did a good post that you can find on our site that lays out the many different areas where the data protection law has significant implications for AI, but to be determined exactly how it will be interpreted. And of course, we look forward to helping provide useful input from what other countries in the world are doing and thinking about, and how India can learn from the successes or challenges of other jurisdictions as it figures out how it wants to lead the Global South and navigate this path forward. Happy Friday, everybody.